1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်951မန်းမြင့်ကြည် applicant versus ဦးကျော် and another respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Miscellaneous Before ဦးကျော်ဆန်းဦး Judge မန်းမြင့်ကြည် Applicant versus ဦးကျော် and another respondents Guardian and Ward Act Section 25 Application by mother for custody of her minor son, minor Tu Yin, to be capable of forming an intelligent opinion of or expressing his view, insanity of father, applicant's financial means to look after the child, applicant not unfit and incapable of retaining the custody of the child, health, the minor, who is a boy, aged about 5 years and who cannot be considered to have passed tender year, is very young yet to be capable of forming an intelligent opinion of or expressing his view. His father is insane and has no means to bring him up due to unavoidable circumstances, for example, insanity of the husband and her own bad health, then applicant had to seek the help of the respondents for the welfare of the child. She has the means to look after the child and there is nothing on the record that her husband would ill-treat the child. There is no dispute that she is unfit and incapable of retaining the custody of the child. In these circumstances, she should not be deprived of her natural right to have the custody of her own child. Fanny Emmeline Peterson versus Ernest Henry Schiff and another 24 Calcutta Weekly Notes page 711 refer to Teng Shan for the applicant, Chambu for the respondents, U Jiao San U Judge. This is an application under Section 25 of the Guardians and Wards Act by the mother for the return of her minor son, now aged about 5 years, to her custody. The respondents are the boy's and father, elder sister, and her husband. The father is insane and is residing with the respondents. The parties are Burmese Buddhist. The applicant is now about 20 years of age. She says she was married in the year 1322 BE 1960. So she must have been quite young when she got married. About a year after the marriage, when she was in the family way, her husband became insane and she was helpless. After the birth of the child, she took a second husband with the knowledge and consent of the relative and elders, including the respondents, and when the child was about 11 months old, the respondents took him to their house, which is next door in the government barracks, to sleep with them at night. It appears from the evidence of the applicant and of the witnesses that the trouble arose when the census was prepared. The child name was entered in the list of the respondent household as well as in the applicant's own list. The question then arose in whose list he should be enrolled. The elders decided that his name should stand in the respondent list. The applicant alleged that the boy was confined within the walls of the house or room by the respondents, not allowing him to come to her as before. The minor calls the respondents Ape and Ame, and his stepfather Ape. The applicant has a child aged about a year old now by her second husband. She is now earning Jet 104 per month and her second husband Jet 90 per month. According to Dojin May, plaintiff witness 2, the maternal grandmother of the minor, the respondents took the child at night to sleep with them from the time he was about 2 years old and only when the applicant married a second time. The applicant brother-in-law, U Tin-Min, plaintiff witness 3, deposed that the trouble started when the minor was enrolled in the household list of the applicant as the son of her second husband, the minor stepfather. The respondents, not being satisfied, would not allow the child to go to the applicant's house as before. He confirmed the evidence that the minor was looked after by the respondents at night, while the applicant looked after him during the day. He also confirmed the evidence of the applicant that one day, when the child ran away to the applicant's house from his confinement at the place of the respondents, Mason, the second respondent, forcibly took him away from his hiding place behind the cupboard. A report was lodged at the police station and U Tin-Man, the secretary of the 5-man committee, plaintiff witness 5, deposed that the matter was settled when U Jo, first respondent, undertook in writing that he would not in future take the child forcibly but would look after him properly. U Jo, first respondent, deposed that he fed and looked after the minor from the time he was a child of 11 months, as the applicant was unwell and her husband was insane. She was walking then. He admitted that he was not pleased when the child was listed as the son of his stepfather when he still has his own father, who is insane. He stated the applicant even agreed to give the child to him by a deed, but she changed her mind the next day. He denied the child was kept in confinement, but he admitted that the police warned him not to do so and that he had signed that he would not quarrel with the applicant. He earns Jet 86 per month as an employee in the Water and Sewage Department of the Rangoon Corporation, while his wife, Mason, earns about Jet 300 per month as a fishmonger. He has a grown-up son and daughter. The son is married and has a child, but the daughter is still single. U Tin-Pei, defendant witness 4, a member of the 5-man committee, corroborated the evidence that the applicant at first agreed to give away the minor to the respondents rather than to U Tin-Min, plaintiff witness 3 by a deed, but she changed her mind the following day. As the child bore two names as his father, the witness sent for the parties for questioning. There was a dispute and eventually he enrolled him in the household list of his maternal grandmother, Do Jin Mei, plaintiff witness 2, as the son of Ko Tang Shui, who is his real father. This witness was an overzealous witness who gave his own view of the case to the police without being questioned, to the prejudice of the applicant. I do not think he can be quite relied upon. The parents, no doubt, have a paramount right to have the custody and care of, and the control over their own child. This is based on the law of nature. This right cannot be taken away unless there are very good reasons. Of the parents, the father is to be preferred if the child is not of tender years. But in cases where the father is unfit or the child is of tender years, the mother's right supersedes that of the fathers. This is the law. Now, in the instant case, the minor is only about 5 years of age and cannot be considered to have passed tender years. He is very young yet to be capable of forming an intelligent opinion of or expressing his views. His father, who is being looked after by the respondents, is still insane and has no means to bring him up. Though she has allowed the child to be brought up and looked after by the respondents, the applicant has never abandoned or deserted him due to unavoidable circumstances, for example, insanity of the husband and her own bad health. She had to seek the help of the respondents for the welfare of the child. She still had the legal custody of the child, though she allowed him to sleep with the respondents at night till very recently, when the trouble started and the application was fine. She is earning enough and has means to look after the child. There is nothing to show on record that her second husband would ill-treat the child. The stepfather himself is earning. There is no dispute that the applicant is unfit and incapable of retaining the custody of the child. In these circumstances, she should not be deprived of her natural right to have the custody of her own child. I'm also of the opinion that it will be for the welfare of the ward to return to her custody. In a somewhat similar case of Fanny Emmeline Peterson vs. Ernest Henry Schiff and another one, a posthumous infant about 3 months old was made over to his aunt, mother's sister, by the mother as she was going to be trained as a nurse. When the mother was in a position to maintain and educate him, having been qualified as a nurse and permitted to have private practice, she applied for the custody of the child, who was then about 7 years old. The infant called the aunt mother and the mother applicant as aunt. The aunt was earning a very decent income and has 2 children of her own. She was very fond of the minor, whom she supported uninterruptedly right through with no help from the mother. It was held that a mother cannot be deprived of her natural right of absolute control over her own child. 1. There is no suggestion whatsoever against her character or fitness to act as the custodian or guardian of her own son. As the custodian or guardian of her own son, for all the reasons given, I allow the application and restore the minor to the mother applicant, but this will not prevent him from sleeping with the respondents at night as he used to do, if he so wished, or visit them at any reasonable time. In the circumstances of the case, the parties shall bear their own costs